Okay, what we're going to do today is we're going to talk about probate and the different types of administrations, assets that pass outside of probate and those that must be probated, what happens when a person dies without a will, which is called intestate, who gets what, and the basic rules of intestate succession would be different if you had a will versus not having a will, and who can act as your personal representative or executor. First, let's talk about what is probate. Probate is basically the system that is used through the court, and every state has some sort of probate system. So if you have any assets that are in your individual name, those assets have to go through a process with the court in order for them to pass on to the next beneficiary or heir, depending on whether you have a will or you don't have a will. This can be costly. Definitely can be time-consuming, depends on what state you are. In some states it might be quicker. We live in Florida. It is very slow in most counties in Florida. They have been trying to streamline that process, but unfortunately that streamline has not caused it to be faster. It has now caused actually more delays. There's different types of probate administrations, and they're called different names depending on what state you're in. Because we're in Florida, I'll be using Florida a lot as our examples. The first type of administration you have, which is the biggest administration, is called a formal administration. And what that is when you have a personal representative, which is what we call it in Florida. In other states it might be called the same thing, or it might be called an executor. And the formal administration has somebody appointed in order to handle everything on behalf of the estate. Then what happens is that personal representative, they file tax returns, they file an estate inventory, they go through everything that you have, and it's a process that requires publication in a newspaper for any unknown creditors, in addition to notifying by certified mail any known potential creditors, giving any creditor an opportunity to file a claim against the estate. Once the claims period has expired, then all creditors are ascertained and they're either going to be paid or the personal representative has objected to them and is either fighting the claim or it's going to expire if the claimant does not file a lawsuit against the estate to get paid. If all goes well, then several months into the process, the estate can then be distributed. Now, in the interim, they would have had to sell all of the assets or determined if they're going to distribute the assets as they exist. For example, if there's a piece of real estate, instead of selling it, the beneficiaries may decide they want to take title to the real estate. They will have filed the tax returns, final income tax returns, potentially an estate tax return. For simple estates under $5.34 million currently, there wouldn't be an estate tax return, but a determination may be made by the CPA and the estate and the probate attorney as to whether or not the return would need to be filed. This process, shortest I've ever seen it happen in my career, was a little under 5 months for an extremely simple estate. I have others that have been going on for many years, and it doesn't always matter how much money is in the estate. It could just drag on for many reasons. So it can be costly, it can be very time consuming, and most importantly, there's issues of public information, because once you file an administration with the court, certain things become public. Who are the beneficiaries? What's the inventory of the estate? So you should really potentially think about alternatives to probate, like trusts, which is another topic for another seminar. Formal administrations generally have a criteria in order to do them. For instance, in Florida, if the assets are over $75,000 and the person has been dead for less than 2 years, then you normally would have to file a formal. The alternative might be a summary administration. Summary administration is a shorter form probate, where in Florida the assets are under $75,000. That's the probate assets. Or it doesn't matter how much the assets are if the person has been dead for 2 years. The idea being that after 2 years, no creditor can come forward. So then it doesn't matter. You don't really need to go through a formal administration to publish to creditors. Summary administration shouldn't really take very long, but unfortunately with the way the courts have been working, it still could take a few months. There are ways to hasten the process by going into court and actually appearing before the judge and asking him to sign the orders in person rather than doing everything by mail. But this is a shorter form. No administrator gets appointed. It has to be a relatively simple thing. You can't have assets that need to be sold within a summary administration. In this type of administration, you basically petition the judge and say, here's what we have, and here's how it's going to be distributed, and you have to list the names, exactly the percentage or the amounts that has to be distributed, and the judge signs the order, and you're done. There are occasions where the judge will require publication, in which case you're going to have to wait the publications period, and on the order put in the creditors who are going to get paid, who will get paid before any beneficiaries. There's also something called an ancillary administration. That's where the person is living in one state and files their probate in that state, but has real estate in another state. For instance, if I'm domiciled in Florida, I file a Florida probate, but I own property in Georgia, I also have to file an administration in Georgia, which is called an ancillary administration. There are ways to avoid that. Also, putting the property in a living trust would help avoid that. Having a limited liability company would avoid that, because a limited liability company interest is personal property, not real estate, and would avoid an ancillary administration. Finally, we have what's a very, very simple type, which is called disposition of property without administration. And what this is the assets have to be minute and essentially be enough to reimburse for funeral expenses. So this can be done without an attorney. A person can usually go to the clerk and handle this, but it's usually when it's a few $1,000s and somebody paid for the funeral expenses. So they would go in and file this type of administration in order to get themselves reimbursed, and you don't have to file any formal probate. We talked about, on the other side, we talked about what probate is. And what I started off with is if you have assets in your individual name with no beneficiary or no joint owner, then those assets are going to have to pass through the court in order to pass on to the next person. There are, however, assets that can be turned over without any sort of court process. Life insurance, where you have a beneficiary, can go without probate. Two things you need to keep in mind. Number one, the beneficiary has to be living. If the beneficiary predeceases you and there's no living contingent beneficiary, the asset will go through probate. So it's extremely important to make sure you keep up with whom your beneficiaries are. In addition, if you leave those proceeds from the life insurance to someone who is under the age of 18, and we're talking about this a little bit later, there's potential for them to need a guardianship in order to receive those proceeds. Assets that are held jointly with as joint tenants, tenants by the entireties, or community property will not go through probate. For instance, and it should actually be joint tenants with rights of survivorship. There's a little bit of a typo here. That's where you and I own property together with right of survivorship. If I die first, it automatically passes to you by operation of law. Tenancy by the entirety is essentially the same thing, but only applies to husband and wife. So if you own in states where tenancy by the entirety is applicable, then you have the property will pass by survivorship to the surviving spouse. And then community property, there's only 9 states in the United States that have community property. Applies to husband and wife, where each party, it's very similar to rights of survivorship, and the property will pass by right of survivorship. Also keep in mind that with joint tenants, not tenants by the entireties, you can have more than 2 people. So if you have 3 people who own the property as joint with rights of survivorship, then if one dies, the other 2 now own it 50-50. and then the final survivor will own the whole property. And then also keep in mind that at the end of the rainbow, when the first spouse dies or when the second to last joint tenant dies, now all of a sudden you own that property as an individual, back to the probate situation. Property that's held in a living trust, known as a revocable living trust or an inter vivos trust, those trusts avoid probate. The reason being that you don't own it as an individual, you own it as a trustee. So with the trustee having what we consider legal title to the property, it doesn't have to go through probate because an individual, which would be you, would be the beneficiary during your life, but at your death it would pass on to whomever else you named as beneficiaries in the trust. So that's another way of avoiding the probate process. Retirement plans, IRAs, 401ks, or other retirement plans that have named beneficiaries. Same as with life insurance. You would have the beneficiary receive it by operation of law at your death. But again, you got to make sure your beneficiary survives you. And two, if it's a minor beneficiary, this actually with retirement accounts, there's a lot of complications with minors as beneficiaries. But most importantly, you've got issues with potential guardianship of the property for those minors. Payable on death accounts or in trust for accounts, that's where you have a bank account in your name. No one else co-owns that, but at your death you have a beneficiary listed. Again, same situation. Make sure your beneficiary is living at the time of your death. And if a child is named as that beneficiary, then there's a potential for having to go through the guardianship of minor process. Assets that pass through probate. So we've talked about what doesn't pass through probate, but what actually does pass through probate. So real estate, anything in your own name where you don't have any joint owner on it. If you own it as what we call tenants in common, which means that if two people own property as tenants in common, they each own 50%. So if one of them dies, the other one doesn't get that 50%. It has to go through your will or through the intestate process. So the remaining tenant owns 50%, and then whomever your heir is will own the other 50%. Bank accounts in your own name. So you have your normal bank account, but you didn't put any beneficiary, any in trust for, or payable on death beneficiary. That's going through probate. Any other asset in your own name. The thing most people don't think about is closely held company. What if you have a corporation? You're a doctor, you have an MDPA. All those things are individually owned assets. So when you die, they have some sort of value, and in order to either continue the company, sell it, or do anything with it, even potentially just having to run the company, you've got to have an administrator appointed, a personal representative, in order to continue that business and get any value out of it. Stock certificates, if you own IBM, Facebook, any of those that's owned in your own name, no joint owner, not in trust for, not POD, those items have to go through probate. And basically, any asset, as we talked about before, with a beneficiary who's listed, except that beneficiary is already dead. So now to the crux of what we're talking about. We've talked about probate. We've talked about the assets that don't go through probate. But now let's talk about if you have to go through probate and you have no will. One of the common misconceptions is that if you have a will, you avoid probate. And I'm going to dispel that right now. If you have a will, then what happens is that you actually make the decision as to where your assets are going to go. Whereas if you don't have a will, it's going to go through the state's intestate laws. And what the state statute says is going to dictate where your assets go. And a lot of it will depend upon who are your immediate family members. And that's how we talk about everything, how it goes through intestacy. The way it works essentially is that if you are survived by a spouse and children, each state will have laws as to what share your spouse and children will get. Until recently, probably the last few years, Florida law stated that if you died with a spouse and children, then your spouse got 50% of your probate assets and your children got the other 50%. Now the law has changed to say that if you are survived by a spouse and children, but your children are all children with that spouse, so the same parents, then your spouse would get 100%. If your children are not all from that spouse, then it goes back to the 50-50. The idea being that most people would probably have wanted their spouse to get it all and take care of the children rather than leave it to the children, because the children would need some sort of guardian of the property. It could be expensive, it's restrictive. So the law changed to reflect that. Many people think that if I don't have a will, my assets are going to go to the state. The answer to that is it almost never goes to the state. The only time the state is going to take your assets after you're gone is if they can absolutely find no one who is not a beneficiary, who is a relative. And it'll take years before the state will ever take possession of your money. In fact, a little tip: if you've ever lived in any state, you always want to randomly check that state's unclaimed property site, because many times there's property on there. Even while you're living, you can check this. They do it all the time. You go on there and you can see if there's any unclaimed property for any relative or for yourself. So in intestate, and again we'll use the Florida law, and we talked a little about this. If you are survived by a spouse and no children, your spouse will get everything. If you are survived by a spouse and children, then it's going to depend on whether or not your children are the spouse's children as well. If you have homestead property in the state of Florida, meaning your residence, which is considered your home, there are different laws reflecting the homestead. And if you are survived by no children and no spouse, then the assets are going to pass depending on whether you have parents. If you have no parents, do you have siblings? Do you have nieces and nephews? And there's a whole chart of how it passes depending on who you've been survived by. For instance, no spouse, no children, and you've got one parent living, your parent takes it all. If you've got two parents living, they take it 50-50. If they're divorced, they still take it 50-50. No parents, it's going to go to your siblings. If you have one sibling living and one who died before you but has children, then one share is going to go to the living sibling, and then the other share will be split among your nieces and nephew from your deceased sibling. There's very intricate law with regard to this, so that's why it almost never reaches up to the state, because it could go to cousins, remote cousins. It doesn't really matter. As long as somebody can come in and prove they're a relation, then they will get it. If you have family members that have been adopted, then as long as they are adopted, legally adopted, then they will take as if they are a biological relationship. If you have half siblings under intestacy, then they're going to take a half share. And if you have step siblings, they're entitled to nothing, unless you had a will which would state that you wanted them to take. So steps get nothing, halves get half, adopted, as long as it's a formal adoption, they will get a share as if they were biologically related to you. We talked about this a little bit before, minor children. In most states, minor children under the age of 18 can't own property. So if you leave a minor as a beneficiary for anything, then there's a potential that the court will require someone to come forward and get appointed as a guardian of the property for that person, for that minor. It's similar actually to probate. It can be costly, time-consuming. It's extremely restrictive in terms of how the assets can be invested and what kind of property can be held. And then most importantly, when the child turns 18, they can have the guardianship end and they can get the money. And in my experience, 18-year-olds have no business having any sort of money. So if you planned ahead, had a trust, had even a will with a trust in it, you would be able to avoid such matters. So people don't think about that when they put their beneficiaries for life insurance or for retirement plans, or when grandparents are generous enough to give money to the children. In wills, there are a lot of ways to avoid this, but when you don't have a will, there's no way to avoid it. It's either the money can go to the child because they're over 18, or it can't go and it has to go into a guardianship. Florida law recently changed its rules and at least made a $15,000 threshold. It used to be, didn't matter how much money went to the children, you still had to do a guardianship. Now, if it's $15,000 or over, you have to do the guardianship. If it's under, then it can be given to the parent for the child, potentially put in a Florida Uniform Transfers to Minors account. There are definitely ways around it. But again, if it's over $15,000, I have that situation right now, then it's going to have to go into a guardianship, which can cost them, several $1,000s to set up. Then they've got annual fees for the attorney to file their accountings to the court, and then there's a filing fee. So it could be pretty prohibitive if you've only got $15,000 to deal with. By the time the kid turns 18, it may not be worth all that much. So what would be different if I had a valid will? Number one, you would be the one who could decide how and to whom your assets are distributed. So for instance, if you didn't have a wife or children and you wanted your friend to get your money, then you'd have to have a will. Because if you didn't have a will, well, your parents might get your money, your brothers or sisters, your nieces or nephews, depending on who survives you. You can have been in a long-term relationship with somebody, but if you never marry them, they're not entitled to anything under your estate. So then a will could take care of that. You can also provide, we just talked about what would happen if a minor gets money. You can provide in your will for what happens for a share to a minor. It can go into a uniform transfers to minor account. It can go into trust. It could be paid to parent. There's definitely many ways you can suggest that the money goes so that it can avoid a guardianship. In addition, if you have a will, you get to choose who your guardians for your own kids are, meaning who's going to take care of them when you die. Forget the money. I'm talking about custody of the children. If you have no will, then people are just going to have to step up, and they may not have been the people you would have chosen. So if you have a will, you get to make those decisions. You also get to decide who's going to be your personal representative, because otherwise, again, same as with the guardians, somebody has to step forward and be the personal representative, and it may not have been the person you would have chosen. And finally, with a will, if there's someone you actually do not want to inherit from your estate, you can actually say that. So the only person you really can't disinherit is a spouse, and you can leave them a minimal elective share. But anyone else you can really disinherit. If you don't have a will, you don't have that choice. Now, who's going to act as this personal representative, or in other states we call it the executor? Under Florida law, the first person with priority is your spouse. And now this is, of course, if you have no will, because under your will you would have named who you want. But under Florida law, priority goes to spouse, and then it goes to, if the spouse isn't available or doesn't want to do it, it goes to your adult children. If no adult children want to do it, it can be your mother, father, brother, sister, or any other family member. The rule is that the person has to be either a relative where they can live anywhere, or if they're a non-relative, they must be living in the state of Florida. So you can't have your best friend in New York be your personal representative in Florida unless they're somehow related to you by marriage or blood. If you have no relatives, well, then somebody's going to need to step up. Now, it could be your attorney, a friend, a business partner, a creditor. I'll be honest, it's not the greatest job, so not everybody really wants to step up. There are fees that they can get under the law. They can get, in Florida, they can get 3% inventory, plus there are some additional fees that they can get for extraordinary acts on behalf of the estate. They can get reimbursed for their expenses, but it could be a pretty big job, so not everybody wants to jump forward and do this. But it doesn't mean that the estate would have no personal representative. Somebody would usually step forward. A creditor might do it if there's no beneficiaries and they want to get paid what they're owed, then they may get somebody to step forward and open the estate so that they can get paid.